We all can see each other. So in form number 23, it is in conformity with the provisions of Order 20, Rule 9, Order 20, Rule 12. Okay. Then in that is regard, you can also kindly see Order 21, Rule 42. Order 21, Rule 42. Now, one of the mode of execution you have learned under the provisions of the CPC, attachment of a decree for rent and mean profit or other matters to be subsequently determined. The court has power. This is one of the mode of attachment. Now, the various means of what are the various modes of attachment, the execution that you have learned under the provisions of section 550. Mansi, can you please kindly open section 51? Section 51. In section 51, kindly see that here, subject to the conditions and limitation may be imposed, the decree holder is entitled, number one, delivery of possession specified in decree, that we learned it now, right now, under Order 21, Rule 12. Then number two, attachment and sale without attachment of the property. So that topic is dealt under the provisions of Order 21, Rule 42. Please note that. Under Order 21, Rule 42, attachment is one remedy. Then there is another sale of the arrest and detention is also another remedy which is given by the court. That is there. Then also appointment of a court receiver in the matter. Item number T. That when I discuss with you what the further the modes of attachment, we'll discuss it here. Then item number 24, that is amendment to Andhra Pradesh, we are not concerned. Now kindly see item number 24 ho gaya, that is a decree sanctioning compromise of a suit on behalf of a minor lunatic. You have it? Yeah, in a minor suit, you know that here how the suit is instituted and against whom it is filed. A next friend filed a suit on behalf of the minor. Now, form number 24 is a decree sanctioning compromise of a sanction on behalf of a minor lunatic. When a person is minor and lunatic, so you have to follow the provisions of Order 33 and Order 32 carefully in that regard. This is how the decree drawn up. The suit coming up on that day, the court made a compromise in this regard and appearing so and so and the said minor and the compromise in that regard and the court. Compromise is made under the provisions of the CPC under Order 23. The compromise should be for the benefit of the minor and not against his interest. Then appendix, sorry, yes, these are the appendix, these are conclusion. Oh, okay. Now, I will take you through the various decrees further. Please come back to Order 20. Apart from this mention here, there are other decrees which are passed under Order 20. Now, that I will take you through serially. Contents of decrees. Yes, under Order 20, Rule 9, first we have learned now the decree for immovable property. Then Order 20, Rule 12A, decree for specific performance of a contract of sale or lease of immovable property. Now, under the provisions of Specific Relief Act, Section 15 to 20 Old Act, you have been filing suits for various specific performance when your builder has not given you the flat, or when somebody has not performed the contract. Then your normally prayer is that here that this honorable court be pleased to declare that the agreement of sale is between the parties is valid and binding. Prayer be for a decree directing the defendant to um, perform the part of his contract, namely put you into possession and also to execute the document. So order 20 rule 12a confirm, or for the lease of immovable property. So under the lease deed, for the first term, the lease granted is for 10 years. After expiration, the parties can further extend it for another 10 years. So the lessee writes a letter to the lessor that requesting him that the lease be extended for a period of another 10 years. The lessor doesn't take interest when he demands exorbitant amount of rent or pagdi. In this scenario, the lessee has a right to file a suit for specific performance. Mindly know that a suit for specific performance would not lie in the small causes court. Normally, all suit between lessee and lessor, they go to the small causes court in Bombay under section 33 of the Maharashtra Rent Control Act. But under the scheme of section 19 of the Presidency Small Court, a suit for specific performance would not lie. So you will have to file this suit either in the City Civil Court or Bombay High Court for specific performance of the lease. A decree is passed under Order 20 Rule 12A. Then kindly see that then Order 20 Rule 13, right now it's a decree in administration suit. Now this we already discussed the provisions of section 266 of the Indian Succession Act. Then also form number 7, 8, 9, 20 in appendix D. Then item number C, Order 20 Rule 14 speaks of decree in preemption suit. Now, what is a preemption is not discussed here in the CPC. Nor it is whenever the act is not mentioning preemption, and you will have to see the definition either from the General Clauses Act or the General Clauses Act, Central Act, or the State Act. We have in Bombay City, we have a Bombay General Clauses Act. The definition can be seen in that. Otherwise, if it is not there in the General Clauses Act, then you can see the definition in the dictionary meaning. Now, you know that the law preemption was developed in India during the Mughal times region. It is purely an Islamic law where the law of preemption was dealt under. You all know that the doctrine of Shufa in Islamic law, in the first year of LLB, you must have learned this. Doctrine of Shufa, S-H-U-F-A, Shufa. Shufa means a preferential right. Preemption means a preferential right to purchase of the purchaser, a preemptor. For example, A and B are two brothers staying in a joint family together. A wants to sell his property to C, who is a stranger. Now here B, who is in occupation along with A, can bring a suit for preemption, that he has a right of preemption. Though under the Indian law, there is no statutory law in the Central Act, but certain states like Punjab and Agra. Mansi, can you just see Preemption Act of Punjab? Can you open this? Preemption, I think 1934 ka act hai. See, the Punjab has a Preemption Act. Their act. You just remember this. Punjab has a Preemption Act, I will tell you. Then Agra also has got a Preemption Act. Apart from these two states, and I don't think any other states in India have a preemption. So we all of this concept of preemption is well known to recognized by the Islamic law. Now under the Transfer of Property Act, when you open section 44, there's a proviso. Mansi, can you open section 44 of the Transfer of Property Act? There's a proviso.
So Ashish has a quick question.
Yes, Ashish, bataiye.
Sir, so this is applicable only in Punjab and Agra, sir, not in the rest of the country?
In the rest of the country, you can have a contract. this can be enforced by contract. If you enter into a contract with A and B, a builder, say that here the next road flat should not be sold by the your neighbor to anybody except you first. Now in Maharashtra Cooperative Societies Act, there is a rule, there is a provision that here the member should give a preference for sale to the members, isn't it? Have you heard
Yes,
of this? There's a
yes,
bylaw.
sir.
That
Yes,
is
sir.
a,
I thought it was only for neighbors. I didn't know it was for anybody in the society.
anybody. You have a right to sell it to outsiders later on, but your neighbor can stop you from selling it out. Now, under this section 44 proviso, kindly be seen. Proviso, section 44 speaks of transfer by one owner, one co-owner. How the transfer is permitted by one owner to co-owner. The provisos say that where the transfer of a share of a dwelling house belonging to an undivided family is not a member of the family, nothing in this section shall be deemed to entitle him to joint possession other or other common part enjoyment thereof. Now here, this particular proviso indirectly says that here a joint owner cannot transfer his share to outsiders. Now, this particular section 44 came up for consideration before the Supreme Court in the famous case of Dorab Kawasji Marden, the Dorab Kawasji, the Warden's case. Mansi, can you open this? Dorab Kawasji Warden versus Kumi Sorab Warden. That is AIR 1990 Supreme Court. It is page number 867. Now, in this case, what happened? These are two cousins, Dorab and Kumi. They sold it's a bungalow at Carter Road now, which has been sold to Sachin Tendulkar. Prior to Sachin Tendulkar bought this property, this one of the brother had sold his part of his share to Raheja Builders, and which was objected to by the plaintiff. He filed a suit. You cannot sell it to Raheja Builders, who is an outsider. I am in joint possession. It's a joint family property. It cannot be sold. So he sought in an order of injunction from the court that the third person, that the builder, developer, Raheja Builder, should be removed from the possession. At the most, he has only a right to file a partition, and he cannot come and occupy the premises. When the Bombay court declined the injunction, ultimately he went to Supreme Court. Now the Supreme Court granted a mandatory injunction. Kindly, Mansi, just open the relevant portion of mandatory injunction can be granted under section 44. There is a observation, beautiful observation of the Honorable Supreme Court. A mandatory injunction can be granted. See, yes, the court granted an interim mandatory injunction, directing the defendant not to induct anybody. He had put the strangers. He says strangers cannot occupy. So this is indirectly based on the doctrine of a preemption. Preemption law during the, yes.
Sir, isn't Partition Act also having similar kind of provision?
Partition Act also provides that if there's a contract between the parties, if the dwelling house is there, joint family, it cannot be sold. It cannot be, you cannot bring the party outsiders. But the outsiders rate is if he files a suit for, if a suit files a suit for partition, he may succeed. That he cannot object under 44. His remedy is not to come and occupy immediately, but he can make a partition. Then the court may separate the premises. If it is a separation is possible, a decree can be passed. But if there is a contractual relationship between the parties, A and B, that you should not sell the land to outsiders only to me, the two brothers may agree upon the death of a grandfather, father, two brothers may agree in a contract, or the father, they can put a stipulation in the will, my children should not be allowed to sell this property to any outsiders, and it should be a joint family property. It should remain in the family itself. And if it's sale to be effected, one son, the other son can purchase it, daughter can purchase it, family purchase, no outsiders. So that is a law of preemption, which is recognized in Islamic law, know that here. During the Mughal region, and the country had, we were governed by the Islamic law. So law of preemption, that is a doctrine of Sufa, was very much in vogue in India. Now that has been recognized. That has been recognized. the parties are have a contractual obligation, they can enter into a contract. You cannot sell it here. That is why a decree for preemption is passed by the court under the provisions of Order 20 Rule 3. Yeah, in a preemption mean you have a preferential share of purchasing the property. If A and B are staying together, A cannot sell the property to C. See, the court will say that the B has filed a suit for preemption. It is ordered and decreed that the sale should take place to B, and the agreement between A and C should be set aside. I hereby direct that A should sell the property only to B and nobody else. That's a decree passed, a decree in preemption suit. Then we already learned Order 20, Rule 15. We learned about the partnership. I won't be specific again. Then 16 speaks of account between the principal agent. Then 17, yes. Then see, Order 20, Rule 18, decree in a suit for partition of property, separate possession of a share. Now, if a suit is filed by strangers under Section 44, if separate possession and partition is possible, then is the remedy possible under the Transfer of Property Act. So the court can pass a decree under Order 20, Rule 18 in that regard for separate possession. Then Order 20, Rule 19 and 20 deal with a decree in set-off and counterclaim. So we learned that here under the provisions of Order 8, Rule 6A, the defendant, not apart from filing the written statement, he has a right to file his counterclaim as well as set off, isn't it? So when it is a separate suit by itself, if a suit is withdrawn by the plaintiffs, counterclaim and set off will survive. So the court has a right to pass a decree in set off and counterclaim in conformity with the provisions of Order 20, Rule 19. And see, this is the provision relating to decree, which is under Order 8, Rule 6A. So these are the various decrees which are mentioned in Order 20. Then various how they are executed is Order 21. Okay. Now these are the various decrees which are mentioned. Apart from that, there are various suits under the CPC. When you see the Appendix A ke andar, Behisab suits are mentioned, because they are not included all the decrees, but the provisions of Order 21 will take in execution, and some more decrees will come how they are executed. So before I take up the provisions of Order 21 execution application, now anybody has any doubt? So far we have discussed, namely judgment and decrees and the various forms under Appendix D and Order 20. Please ask me quick questions before I proceed to the next topic.
So Ashish here.
Yes, Ashish.
So the agreement not to sell to outsiders is in perpetuity, or is it for some fixed period of time?
It is in perpetuity also. It can be between the parts so long during your lifetime, and also your heirs can execute it. Your heirs also can execute it. It is binding, no? When a person dies, you can bring the heirs and record under Order 22 of the CPC. And if for some reason you have sold it to outsiders, outsiders also have to come and record under Order 22, Rule 10 CPC. And sometime there is a provision in the CPC, suppose during the pendency of the suit, the defendant has sold the property by assignment to a stranger. The stranger has not chosen to come and record under Order 22, Rule 10. Now, ultimately, a decree is passed. Against the defendant in favor of plaintiff. The plaintiff. Now, what is the remedy of the stranger who took the contract? He has not come and record. Does it mean that he cannot execute decree? Yes, he has a right to execute decree under the provisions of the CPC, which I will discuss under Order 22, Rule 16, and also under Section 146 that we'll discuss now when we deal with execution. Okay?
Okay.
Anybody has more question, please ask me. Hai kisi ke paas aur question? Yes. Now the next topic which I am going to take up. Now, yes, 1 minute. Give me 1 minute. Now, how we have learned this, the passing of the judgment decree. Now we will see how to execute decree. The Privy Council has rightly said it here. Obtaining a decree in Indian court is difficult, and more difficult is the execution. To how to implement execution is more difficult. Very cumbersome procedure is laid down under Order 21. There are maximum rules are there. Rule 106 tak aap dekhen aapne. So we will run through the various provision. Now, what is the meaning of execution again has not been explained. Please note that here. Neither in the CPC may be defined nahi kiya iske andar. Now CPC, what the execution means? Execution means it's a process for execution. It's a process for enforcing or giving effect to the judgment of the court. Execution means it's a process for enforcing or for giving effect to the judgment of the court. How to give effect to the judgment of the honorable court, a judgment and decree which has been passed, how to enforce it. That is the meaning of execution. The CRPC mein execution ka matlab phansi, sending to gallows. But in the CPC here, execution of decree mean how to implement the order, how to implement the decree and judgment which has been passed by the honorable court. Now, let us see the provisions here. Now, first provision will be who can apply for execution. Is it only the plaintiff, or also the defendant, or third person, or other person? Now, that of course that has been spread out everywhere in the CPC. I will give you briefly what are the various provisions. Now, please note it down correctly. Who can make? Number one, a decree holder can apply. First person who can apply, a decree holder. That definition you have seen in the CPC, isn't it? That don't have to mention under section 2, a person, a plaintiff who filed the suit in whose favor decree has been passed. He can apply for a decree. He can apply, that is under Order 21, Rule 10. When you just open Order 21, Rule 10, dekh leta hu main. I will briefly explain. Yeah. Mansi, open this Order 21, Rule 10. Application for execution. Where a holder of a decree desire to execute, he shall apply to the court which passed the decree to the officer for execution. That is the provision. I won't be reading, master. Number one. That is Order 21, Rule 10. Number two. Then number two, the legal representative claiming under the decree. Now see that the second person who can execute decree is the legal representative. Now the expression legal representative is defined under section 2, 10, 11 of the CPC. A person who intermeddles, a person who intermeddles with the property. Legal representative definition kindly see or 211 ke andar. Legal representative mean a person in law represent the estate of the deceased person, including a person who intermeddles. It is not only the heirs, children. It is not only the persons entitled to under the will, but also persons who intermeddles, creditors. Suppose your grandfather or father has taken loan from the bank. A creditor also is a legal representative. So he can intermeddle. Now, this definition of legal representatives of a decree holder, that you can kindly say section 146. Section 146 kholiye is very interesting section. Yeah, section 146. The proceedings by or against representatives. The save as otherwise provided by the court or by law for the time being in force, where any proceedings may be taken, application by against person, when the proceeding may be taken or application may be made by or against any person claiming under him. Now you learn that here, this section is a supplementary provision or additional provision, or you may say that a provision enabling provision. Now, for example, a plaintiff, the plaintiff has filed a suit. Plaintiff has filed a suit against the defendant. During the pendency of a suit, the plaintiff has sold the property to Mr. X by virtue of assignment. Now, an assignee has a right to be brought on record and continue the suit under Order 22, Rule 10. Please open Order 22, Rule 10. He has to obtain the leave of the court. See the procedure in case of assignment before final order in the suit. In cases of assignment, creation of devolution of any interest during the pendency of a suit may, by the leave of the court, may continue or against the person or upon such interest or dissolve the attachments also. Now, this provision enables the assigner to come on record as the plaintiff in place of the original plaintiff. That is called substitution of the parties. But in the case of the heirs, that is a son, daughter, if a plaintiff dies, they have a right to come on record within 90 days and continue the suit. If they don't come, if they come on record under Order 22, Rule 4, Order 22, you can see that here, procedure where the several plaintiff dies. Order 22, Rule 2 and 3 and 4. Where the plaintiff defendant dies, they should come on record. If they don't come on record under Order 22, Rule 9, the suit is abated within 90 days. Then application for setting aside the abatement under Article 121 would lie within 60 days. That you learn that here. Now that is not there. Now the heirs, now here I'm talking of a case for the purpose of 146, that the assigner to whom the property has been assigned has not made application before the court. The suit was part-heard. Recording of evidence is maybe over. Before the argument taking place or during the course of the argument, the plaintiff sells the property to B, Mr. X. He doesn't come on record. Now, after 3-4 years or maybe 3 months, he learns that decree has been passed against the defendant. It may be a summary suit or it may be a regular suit for recovery of 1 lakh, 10 lakh. So the no sooner he came to know the decree is passed, now he will consult his lawyer. He will approach you as a young lawyer. What is my remedy now? The plaintiff had filed a suit against A had filed against B, and a decree is passed for recovery of 1 lakh or 1 crore. That defendant is, the plaintiff is actually no more. I have taken all the rights, or I have not come on record. Will I get the property or not? Will I get the money or not? So, having not made the application under Order 22, Rule 10, you cannot say that you can be debarred. No, that is how the provisions of Section 146 is there. So, the proceedings can be continued. Now, one of such cases which came up for consideration before the Supreme Court was, in a case like this, under order when the heirs were not brought on record, is the case of I'll discuss this AIR 1995 Supreme Court, page number 376. The parties name are Jagal Kishore versus Raw Cotton Company. Now, just before I discuss this judgment to you, I just mentioned to you that the legal representatives claiming under a person can execute decree under 146. Now, there is one more provision, Order 21, Rule 16. Kindly see that Order 21, Rule 16.
Sorry to interrupt, only 9 minutes are left.
9 minutes. I will cover this topic. I will come later on. Under Order 21, Rule 16, kindly see that there is a provision which says that here, application for execution by transferee of a decree. Read this here. Kindly open one, see. Where a decree or a final decree has been passed jointly in favor of two or more persons, the interest of any decree holder in the interest is transferred by assignment in writing or by operation of law. Transferee may apply to the executing court which passed, and the decree may be executed in the same manner and subject to the condition if the applications were made by the decree holder. Now it's very interesting here. Now here, under the provisions of Order 21, Rule 16, a transferee of a decree, that means A and B, A the plaintiff, B the defendant, A has assigned the property to C, who has not come on record, can he execute the decree on record? Now there are two modes here. Now during dependency, the decree holder, it says that here, by virtue of assignment is the first mode. Secondly, by operation of a law. Kindly note that here, operation of law. And thirdly, transfer be made execution. Now we have to understand here that how the court is permitting execution and giving the benefits of a decree to a third party who has not come on record. Because under the provisions of Order 22, Rule 10, the assigner has to make application. He has not made it. He is only come to eat the fruits of the decree. That maybe the plaintiff is dead and gone and not available. And this man said that I have purchased the property. So when you have purchased the property, now the Supreme Court construed here whether the operation of law, in the operation of law and a decree is how many types of a decree here, how it can be enforced, whether it is an equitable transfer or whether it is a permissible for the court to allow such order came up for consideration in Jagal Kishore versus Raw Cotton Company's case. I would like to discuss this lengthy judgment. Anybody has any doubt, you ask me so far on the provisions of Order 21, Rule 16 and under the provisions of Order 22, Rule 10. Anybody has any doubt so far? Because this topic will take at least one full lecture. But who are the person who can execute decree? It is not only the plaintiff, but also legal representatives. A representative who was not a party in the suit can execute the decree. And sometimes even the defendant can execute decree. In a partition suit, you know that here, the plaintiff has to ask for not only his own share and his sibling in a partition suit. My brother, defendant and sisters have an equal right under the Hindu Succession Act or under the Islamic law, their shares are specified, they get it here. So the defendant also can come and execute decree. In that matter, that I will take. Yes, Ashish, put the question.
Sir, assignee, sir, he cannot come and file a condonation of delay if he has not come on record.
If he makes an application for condonation, the court may consider it. Suppose in a case, I am going to deal with a case that is AIR 1955, Jagal Kishore's case, Jagal Kishore Saraf versus Raw Cotton Mill. The assigner did not make application at all. If you make the application, then normally the courts are very liberal in condoning the delay, invoking Section 5 of the Limitation Act. The court like to see that here no party should be heard, should be condemned unheard. Opportunity must be given so that the merits of the case are discussed properly. But here in the case, the assigner was sleeping over all throughout. Here, what happened in this case, Habib and company, you must be aware of. This is prior to partition, the suit was filed in in the City Civil Court, Bombay. Habib and brothers filed a suit against Jagal Kishore Saraf for recovery of certain amount. And these Habib brothers, ultimately after partition, they migrated to Pakistan. And when they migrated to Pakistan, you know that when you migrate to Pakistan, the property left behind by such person, that will be coming under the Evacuee Property Act. Have you heard of this? Mansi, I'm sure you must have heard of it. Evacuee Property Act nikaliye. There's a custodian of evacuee property. Please note that the property of a person, who left India during partition, went to Pakistan, left behind, like Jinnah's property in Bombay was declared as a evacuee property. And now the Jinnah's heirs, his daughter, Nasli Wadia's daughter, he is fighting before the court. No, we are the heirs he wanted here. Isn't it? So the property of the Habib brothers was declared evacuee property, but the administrator, and there is an administrator under the evacuee property who decides the right title interest. In the right title interest, this gentleman, that is Raw Cotton Mill Company, they filed an application after when ultimately what happened, the Habib brothers went to Pakistan, they did not follow the suit. But the learned judge, before whom the full full material was placed before the court, in a summary suit, you know that evidence is not recorded. What is there? There's a plain, there is a leave to defend, there's a summons for judgment. Isn't it? These are the documents before the court. And the court peruses the document under Order 737, Rule 1 and 2, and passes a decree. So accordingly, a decree was passed in favor of the plaintiff, the original plaintiff, Habib brothers. Habib brothers, for recovery of certain amount in a summary suit. And they migrated to Pakistan. The gentleman, the assigner, the assignee, that is Raw Cotton Mills, thereafter, after the decree is passed, they were aware of the fact that before partition, they could have gone to the court and made the application. They chose not to make it. Then they made application for execution under Order 21, Rule 16. Under Rule 16, the interpretation word here, what happened? The assignment was passed. The assignment was before the passing of the decree. Interesting, see that here. It is not, the decree is not assigned.
Sorry to interrupt, sir.
Yeah.
So only 1 minute is left.
Anybody has any question? No, what was assigned was, I will say what was assigned was only the properties and the suit. And there was no assignment of the decree in this case, in Jagal Kusher's course. When you are not assigned, when decree is not assigned, provisions of Order 21, Rule 16 do not come into play. It is only after the passing of a decree, assignment can take place. But when assignment of a decree has not taken place, when only assignment of the suit has taken place, along with the other property, can such a person make application? Was the subject matter of discussion in this leading case, Jagal Kusher's court, which I will discuss tomorrow in my next lecture. Yeah? Anybody has any questions so far, please ask me. Jagal Kishore case, please read and come this judgment. And also the another judgment of the Supreme Court, whether preemption decree, that is also read and come, 1979, page number 1066, Zila Singh versus Hazari's case. How the preemption decree was transferred. That is